The night before brain surgery, I thought about death. I searched out my larger values and I asked myself, if I was going to die, did I want to do it fighting and clawing or in peaceful surrender? What sort of character did I hope to show? Was I content with myself and what I had done with my life so far? I decided that I was essentially a good person, although I could have been better. But at the same time, I understood that cancer didn't care. Lance Armstrong. What if you were in a hospital with no prior expectation of a life-changing event, and or even a changing event for your future? Surgeons and nurses pass you as you lay on the operating table for a simple procedure. You slowly fade out with anesthesia. You blink your eyes open and realize that you can't hear the nurses as they open their mouths to tell you, to ask if you're awake. They start pointing to a whiteboard to say that your life could possibly be changed forever. They overdose the anesthesia, causing you to become deaf. The hospital staff made a simple error, however, it was a life-changing mistake. Naturally, after the situation, you are distraught and want to prevent other patients from undergoing the same mistake, and you want compensation for your loss. Thus, you sue the hospital. This is where medical malpractice becomes necessary. Attorneys practicing medical malpractice realized that there was a breach in care of the hospital and the importance of holding them accountable in order to protect future and current patients. This legal field also influences the hospital's policies and procedures, which can further influence patients and their treatments in the future, not just with what was affecting them in that time. Which is why I chose to pursue a study of medical malpractice alongside an attorney with knowledge of the field. I want to introduce you all to a special guest, Mrs. Amanda Lockmiller, my mentor this year. Thank you for mentoring me. You have inspired me to pursue my aspiration to become an attorney. Thank you all for coming to support me tonight. Before I begin, I'd like to introduce you to me. When I'm not at Strasburger and Price with my mentor, I'm usually involved in student council, where we learn about how to work in the environment and kind of just really encourage school spirit as well as volunteer work in the community. I'm also part of Prestonwood Baptist Church, where and I'm involved in the student leadership there for choir. And I'm also involved in choir, National Honor Society, National Technical Honor Society. Most of these really encourage volunteer work and encourage students to continue to maintain a good GPA throughout the school year. And I really enjoy being able to volunteer inside the community and outside the community. I'm also a Breathe Bible Study leader at my school. I'm an FCA leader at Hunt Middle School, and for the past 2 years I've been a part of the FHS debate team, otherwise known as the forensics team, and it has really been a great opportunity for me to become a part of the debate team, in that I was a part of the section of debate, the pro section, where we were able to harness our speaking skills and be able to increase our knowledge of how to speak in front of a crowd and compete. And then also I was involved in the Congress section, which has definitely encouraged me as far as researching different legislations and developing an opinion and an argument about different legislations, which is obviously needed in order to pursue a career in law. I just wanted to, before I start defining medical malpractice, I wanted to tell you why I joined ISM. I joined ISM because I'm interested in becoming a part of the law field, and last year I actually started my journey in ISM. ISM has really just encouraged me to continuously pursue the career that I want to belong in. Although I'm in high school and kind of opportunities are a little bit more limited to me than they would to be to a college student or a law student, being an ISM really opens up that kind of box and allows me to pursue the career I want to alongside a mentor and be able to research on my own time. I also took ISM to solidify my decision to become an attorney. I was kind of confused where I wanted to go at first as far as like if I wanted to pursue a career in business, a career in IT, or a career in law. And I think it was really hard for me to be able to understand what I wanted to pursue until I actually started doing hands-on work, so actually researching legal documents, which I've been able to do this year, and being able to have a mentor there who's actually an attorney to like guide me and to show me like what I should be researching and how I should research and how to develop legal documents. And that's really been an amazing part of ISM. So last year I was actually in ISM and I studied litigation, which is kind of like the argument portion of the legal field, I guess you could say. It's where you go into the courtroom and you present your case to the jury and the judge. So last year I was with Mrs. Allison Cross at Strasburger and Price, and we talked a lot about the Hobby Lobby versus Sebelius case. And the Hobby Lobby case was associated with the healthcare bill that had just recently been implemented, which restricted Hobby Lobby to providing a certain type of contraceptive devices which they believed were harming to lives. So Hobby Lobby ended up taking the decision to court and asking them to only provide, asking if they could only provide a certain amount of those contraceptive devices to their employees. So it was really interesting being able to learn about this and being able to see from Hobby Lobby's perspective, so really from a plaintiff's perspective, and how my mentor would pursue that case and how she would develop her argument. Okay, on to medical malpractice. The definition for it is professional negligence by act or omission by a healthcare provider in which the treatment provided falls below the accepted standard of practice in the medical community and causes injury or death to the patient, with most cases involving in medical error. Medical malpractice also involves protecting the plaintiff, often the patient or the family. Attorneys in the medical field often use medical records to prove their case, and they go to court to present the case to the jury. The case often includes the idea that, as I previously said, the hospital or the doctor or even the medical staff breached a duty to the patient or their family, and the responsibility was breached. So this is kind of, this right here, this kind of chart kind of shows like who commits medical malpractice. That's pretty much like the hospital staff, how they have to be aware of the what is it called? Of the risks they're taking as they go into the hospital room to take care of the patient. So anesthesiologists, doctors, emergency room staff, pharmacists, technicians, dentists, hospitals, nurses, surgeons, and therapists. And what you can be compensated for are medical bills, pain and suffering, wrongful death, lost earnings, disfigurement, and loss of consortium. There are different types of medical malpractice: failure to diagnose, misdiagnosis, anesthesia mistakes, wrong prescriptions, wrong treatment, birth injuries, and surgical errors. So all of these, you can sue the hospital, or like I said, the other people who commit to medical malpractice, you can sue them for if they have wronged you. Okay, why medical malpractice? Forget about finding your passion. Instead, focus on finding the big problems. I believe that once you find the larger problems, you will find out what you are passionate about. As I have studied law for the past few years, I have realized that your passion comes from the solutions you work to find. As I said in my introduction, I think it was kind of unclear to me if law was really what I wanted to pursue because I had no idea what it involved and kind of the details that you had to go into as either a law student or a lawyer. And I think that was definitely very very pushing point for me, and I wouldn't have pursued law unless I knew what was included in it and how to find solutions to these different problems in as what I'm studying in the medical fields and in other different fields in court that are taken to court. If you continuously work to find a solution in a career that you enjoy, you'll begin to understand why you enjoyed the career. I've definitely figured this out as I have taken different legal courses. I've taken Law 1 and Law 2, and so this includes civil law and constitutional law. And I've definitely been able to see how this works out, how what I'm learning in my mentorship applies to what I write in civil law. So if I'm developing a deposition, how I might also be writing about how to write depositions in civil law, but I've already learned this from my mentor because of what she's taught me and what they end up doing as attorneys in the professional field. I definitely believe this is true relating to my experience in ISM with medical malpractice, and also I'd say with litigation last year. I definitely wouldn't be interested in the legal field if I hadn't pursued it in ISM and looked for solutions to specific fields in law and how a lawyer would strive to create solutions in each individual field. Here are some of my research highlights. Most of my research was really dedicated into developing my original work and learning how to create a deposition, which was my original work. So it mostly included reading about the Marks versus St. Luke's Episcopal Hospital case and watching deposition videos to help me develop and understand how to develop different depositions and how kind of that process would go. I developed a Marks versus St. Luke's Episcopal Hospital summary, which is very important. I think when you're kind of reading over the case, you want to make sure that you understand fully, you make sure you comprehend what's going on in the case, and I think it really helps to write a summary. I wrote a deposition to a hospital representative questioning where the hospital made an error, and a deposition includes a formal statement that someone makes who has promised to tell the truth, makes so that the statement can be used in court, especially a formal statement that is made before a trial by a witness who will not be present at the trial. So that's from the Merriam-Webster Dictionary. And kind of an attorney's side of that, it's where you develop a deposition. So where you develop the questions to ask, the hospital representative or whoever's being questioned in the deposition. Throughout my research, I really had to understand how to organize the deposition and what information to question the hospital's representative with. So it was really important for me to understand the Marks versus St. Luke's case. And also, I just wanted to show this really quick video of what a deposition looks like to give you guys an idea. Oh, just kidding. So that would be
August 14th,
the hospital representative being interviewed.
approximately 1 p.m. This is the beginning of disc 1 of volume 3 in the video deposition testimony of Karen Michelle Shansky in the matter entitled Linda
Can you like skip a bit of it?
Of the County of Los Angeles, Central
Or
District.
never mind.
Case number BC
Wait.
457-891. We are at the law offices of Brown White.
Yeah, there you go. So that's pretty much what it's like. We'll have like a list of prepared questions, which is kind of like what I wrote, that proves the plaintiff's point that they're trying to get across, that the hospital wronged them, and just really questioning that. So the Marks versus St. Luke's Episcopal Hospital case, here's kind of the background information. Irving Marks underwent back surgery at St. Luke's Episcopal Hospital. 7 days later, while still recuperating from his surgery, Marks fell in his hospital room. He alleges that this fall was caused by a footboard in his room, on his hospital bed, which collapsed as he attempted to use it to push himself from the bed to a standing position. Marks ended up suing the hospital, and he alleged that its negligence contributed to his fall. He complained that the hospital was negligent in failing to train and supervise its nursing staff properly, failing to provide him with the assistance he required for daily living activities, failing to provide him with a safe environment to recover in, and providing a hospital bed that had been negligently assembled and maintained by the hospital's employees. So, kind of what I compiled like a list of things that were breached during the case, and like what the hospital did wrong in the case, and that really helped me to kind of ask questions that that kind of led to these points, like that they failed to install or maintain bed rails on the bed that Mr. Marks was located on. They failed to properly assemble or maintain the bed, as I previously said. They failed to repair and or maintain the footboard on the bed. They failed to properly monitor Mr. Marks, so they didn't have any nurses or staff during that time when he fell, apparently. So the really good questions to ask are like, what kind of narcotics was he on? Was he on anything that would have caused the fall, or were there any nurses who were supposed to be taking shifts there to help him to go up to the bathroom or to give him a glass of water or anything like that? They failed to implement adequate policies and procedures to inspect the hospital beds. They failed to take precautions to inspect the hospital beds and Mr. Marks' fall. They failed to ensure that adequate policies and procedures were in place for hiring, training, and supervision of the nursing staff at the hospital. And they failed to ensure that the persons hired to work at the hospital had a sufficient understanding of the safety concerns for the patients and was competent to formulate policies and procedures for patient safety and quality assurance. The Court of Appeals initially reversed Mark's case, and they reversed it, and they conclude that his allegations concerned an unsafe condition created by an item of furniture and thus was related to premises liability, not healthcare. And he had filed this complaint under healthcare, and he had sued them under healthcare, but they were saying that it wasn't really healthcare, but it was just the bed, so that he should be suing them for liability, not healthcare liability. The hospital appealed, filing its petition for review a few days before the opinion in another case involving the scope of a healthcare liability claim. After full briefing, the court granted the hospital's petition without reference to the merits and remanded the case to the Court of Appeals for reconsideration under the light of Diversicare. Okay, I first want to start and talk about my mentor before I continue on about my original work and my final product. My mentor is Amanda Loffmiller. She is a financial associate at Strasburg & Price LP, which means that she works in consumer financial litigation as an attorney there. She went to Baylor for undergraduate in political science and speech communication. She went to Texas Tech for law school. She previously studied in medical malpractice, and her advice to me during our interview was, in order to succeed in law school, to take good notes, you need to take good notes, ask questions to the professors, be bold, be prepared to study because of competition, and also to know how to cite documents and legal documents, which I've definitely found is important throughout writing a deposition and my final product. It's very important to cite legal documents, or else that's plagiarism, obviously. She said that the law review is something for law schools, which involves mock trials and is beneficial for a future career as a lawyer. Okay, for my final product, I went on to study the Henderson versus Spann case. Let's see. For the Henderson versus Spann case, I went ahead and I wrote an amicus curiae brief, which in simpler terms is a friend of the court brief. So pretty much it would be like an attorney or an association of attorneys, for instance like the Dallas Lawyers Association or something like that. And so it's where they kind of put their own opinion on the case, although they might not be like involved in the case in any way. They put their opinion on that and they send it to the court to review. And that might somehow influence the court's decision, which is why I wrote this brief. A description of the front of the court brief is frequently a person or group who is not a party to a lawsuit but has a strong interest in the matter will petition the court for permission to submit a brief in the action with the intent of influencing the court's decision, just from Cornell Law. The front of the court brief challenged the appellate court's decision only to allow the jury to see adjusted medical bills, therefore preventing the petitioners, the Spanns, from receiving compensation for current and future losses as well as mental and emotional anguish, which I feel is definitely important in this case, which I'll introduce to you now. So some of the facts from the case are, in September 2009, the vehicle Henderson was driving collided with a motorcycle driven by Mr. Spann, an off-duty police officer. Mr. Spann suffered significant injuries to his groin and lower back. The Spanns filed suit, and a Lubbock County jury found that that Henderson's negligence was the proximate cause of Mr. Spann's injuries. Thus, in order to compensate for Mr. Spann's injuries and his past and future physical impairment and medical expenses, the jury awarded Mr. Spann $267,542. The jury's verdict included compensation for Mr. Spann's medical expenses in the amount of $69,000, which represented his unadjusted past medical bills. Eventually, Henderson objected to Spann's unadjusted medical bills being entered into evidence, and they cited that the recovery of medical or healthcare expenses incurred is limited to the amount actually paid or incurred by the behalf of the claimant. So they were pretty much saying that if the Spanns haven't already included the part which the insurance company had already provided and had already taken care of, that just really wasn't right, and they believed that it should only be adjusted medical bills. So the only part, as I previously stated before, the only part that they believed he should have gotten. The unadjusted bills were entered into evidence over Henderson's objection. The court thereafter reduced plaintiff's award for past medical damages to $15,000, which represents the portion of Spann's bills that he actually incurred or paid himself. So this case really questions whether or not the court should provide not only evidence of recoverable medical expenses, but also the medical expenses are actually paid or incurred that are relevant to damages. So as I stated before, this doesn't include emotional anguish or mental anguish. It's just really only a specific amount, and it just went down so much. But they're using this. Henderson is actually using this. His statement or her statement that it should only be unadjusted medical bills, or adjusted medical bills. My bad. And because of the bill, which was recently the medical bill, which was recently passed, limiting to only $250,000 of a medical liability suit. So I really just addressed the flaws in my brief in the appellate court's reconsideration of the admission of adjusted medical bills and exclusion of unadjusted medical bills. Because eventually the case was actually taken to the appellate court because of Henderson's problem with unadjusted medical bills. In my FSC brief, I introduced the issues with the appellate court's interpretation of Section 41.0105, which is the healthcare bill, in Texas. The district court allowed the spans to include unadjusted medical bills. Henderson then appealed to the appellate court, stating that the healthcare bill did not include unadjusted medical bills, challenging the district court's interpretation. So really throughout my final product in my brief, I really just challenged that point and challenged the appellate court's definition of adjusted medical bills and how much the spans are allowed to bring into evidence into the court. And I really think it would be important, as I continue to write my final product, to really stress the point that they need to, that the court needs to include unadjusted medical bills, because I believe that the spans really have the right to that, especially after being in a motorcycle accident like that, which was detrimental to Mr. Span. Overall, ISM has solidified my decision to pursue a career in law. I've definitely been able to use my research and my writing skills in my AP literature class, and as well as other college classes which I will be attending in the future. For college, I am still undecided, but I hope to attend Dallas Baptist University in my future, and Texas Tech or the University of Texas in Austin for law school. Thank you.